A single document, 23 pages long, signed under oath, and now, according to court filings, it may sit at the center of one of the most explosive legal confrontations in recent memory. The number being discussed is $127 million, not because of where the money went, but because of what one affidavit claimed about it. In a federal courtroom, documents surfaced that appear to show something strange. A sworn statement saying one thing, and company records suggesting something very different. Emails, wire authorizations, initials on financial documents, all tied to the same real estate transaction. And when a federal judge reportedly reviewed the filings, she didn't schedule a routine hearing. She cleared her calendar and called for an emergency evidentiary proceeding. Legal analysts immediately started asking the same question. Was this simply corporate paperwork confusion, or something much bigger? Because when statements made under oath collide with authenticated records, the consequences can escalate fast. But to understand how this situation unfolded, we need to start with the document that triggered everything. And it began with a legal strategy that seemed perfectly routine at first. Weeks earlier, Trump's legal team reportedly submitted a sworn affidavit to the court. 23 pages designed to support a key argument in an ongoing civil fraud case. The strategy was straightforward. Distance the former president from the detailed negotiations behind certain real estate transactions. According to the filing, Trump claimed he had no direct involvement in negotiating specific terms, tied to a major deal connected to a Lexington Avenue property. In large corporate organizations, that argument isn't unusual. Executives often rely on teams of lawyers, financial officers, and deal negotiators to handle complex agreements. And companies the size of the Trump organization have hundreds of employees involved in transactions, so on the surface, the defense seemed familiar to corporate litigation. The idea that a CEO might approve things at a high level while others handle the details. But just days after that affidavit was submitted, opposing attorneys filed their response. And that's when the narrative began to shift, because the response included documents that, according to court filings, appeared to tell a very different story. The filing included dozens of internal communications, emails produced during discovery, documents authenticated as official business records, and according to the legal brief, several of those records seemed to contradict the sworn affidavit. One example cited was a wire authorization, reportedly bearing Trump's signature tied to the same, $27 million transaction. Another involved internal email chains discussing the deal's final terms. In one message thread referenced in the filings, Trump's email address allegedly appeared in the CC line of multiple messages. Then came one short reply, 3 words, approved, move forward. If interpreted literally, that response could suggest awareness of the transaction. And if that awareness conflicts with what was stated under oath, it raises questions. But legal questions are rarely simple, because context matters, and lawyers immediately began debating what those emails actually proved. Still, as the documents were examined, more potential inconsistencies surfaced. Initials on loan term sheets, emails discussing interest rates, internal communication referencing approvals. Individually, none of these pieces of evidence prove wrongdoing. But together, they created a growing paper trail that lawyers on the opposing side argued was impossible to ignore. And that paper trail eventually reached the desk of the federal judge overseeing the case. When the judge reviewed the filings, the response reportedly came in the form of a 19-page order. Judicial language tends to be extremely careful. Judges choose words precisely, which is why one phrase from the order quickly caught attention across legal circles. Troubling discrepancies. Another phrase referenced in reports described apparent contradictions between sworn statements and documentary evidence. Those are not casual phrases in a courtroom setting. They signal that the court believes something deserves deeper scrutiny, and instead of addressing the issue during a future trial date, the judge scheduled an emergency evidentiary hearing. That move alone changed the atmosphere surrounding the case. Emergency hearings typically mean the court believes clarification cannot wait. But the situation took another unexpected turn just hours after the order was issued, because Trump's lead defense attorney reportedly filed a motion to withdraw from the case. Attorneys withdraw from cases all the time. But timing matters, and attempting to step away just days before a critical hearing raised eyebrows among legal analysts, especially in a high-profile case involving a former president. The motion reportedly appeared late at night, less than 72 hours before the scheduled hearing. Observers immediately began speculating about what it meant. Some suggested it might simply be procedural. Others wondered whether the legal team anticipated a difficult hearing. But the judge responded quickly. The withdrawal request was denied. In a brief order, the court reportedly stated that counsel would continue representing the defendant through the upcoming proceeding. In other words, the attorneys who signed the filings would remain involved when the questions were asked, and that decision set the stage for what could become a pivotal courtroom moment. While critics focused on the alleged contradictions, Trump's defenders presented a very different interpretation. Their central argument revolved around corporate complexity. Major real estate deals often involve dozens of people. Executives sign stacks of documents prepared by teams of lawyers and financial officers. That doesn't necessarily mean they personally negotiated every detail. In fact, some legal experts noted that CEOs frequently authorize transactions without reviewing every individual term. Supporters also pointed out that the affidavit used specific wording. The claim focused on not having direct involvement in negotiating particular terms, and according to the defense, signing authorizations or approving deals in principle isn't the same as negotiating them. That distinction might sound technical, but legal cases are often decided on technical distinctions, which is why some analysts say the real question may come down to interpretation. Did the affidavit intentionally mislead the court? Or was it describing involvement in a narrow, legally defined way? That question could become central during the hearing. But just when the debate seemed focused on those contradictions, another filing appeared, and it introduced an entirely new dimension to the story. Late one evening, attorneys reportedly submitted a motion asking the court to consider additional documents, banking records connected to an overseas subsidiary. According to the filing, the records involved wire transfers associated with the same transaction discussed earlier in the case. The documents allegedly linked certain accounts to the deal, and some reports claimed Trump's name appeared in connection with the account structure. Now it's important to note that filings like this represent claims from one side of a legal dispute. Courts must evaluate whether the evidence is admissible and how much weight it carries. But if the judge allows those records into the hearing, the discussion could expand significantly, because financial documents tied to international accounts often raise additional questions, and that possibility increased the stakes surrounding the upcoming proceeding. Across the legal world, analysts began weighing in. Former federal prosecutors noted that judges rarely schedule emergency evidentiary hearings unless they believe something serious requires clarification. Some experts suggested the court may simply want to understand how the affidavit was prepared. Others believed the hearing could focus on whether the contradictions were intentional. Intent matters enormously in legal proceedings. Mistakes happen. Confusion happens. But knowingly submitting inaccurate statements under oath carries much heavier consequences. Still, many legal scholars caution that proving intent is extremely difficult, which means the hearing could ultimately revolve around explanations. Who wrote the affidavit? Who reviewed the documents? And what did everyone involved understand about the transaction at the time? Those answers may determine how the court responds. Beyond the headlines and political debates, the case touches on something fundamental to the legal system: sworn statements. Affidavits exist because courts rely on them as truthful representations of facts. If contradictions appear between those statements and documented evidence, the system has to address it, not just for high-profile figures, but for everyone. Civil litigation across the country depends on the assumption that statements made under oath are accurate. That's why lawyers, corporations, and courts are watching closely, because the outcome could influence how strictly contradictions are treated in future cases. For corporate leaders, it also highlights how carefully documents must be reviewed before being signed. Even small discrepancies can become major issues once they enter the courtroom, and that reality brings the story back to where it began. One affidavit, 23 pages, and a hearing that could determine whether those pages were simply misunderstood or something far more significant. As of now, the legal process is still unfolding. The court has scheduled the evidentiary hearing. Both sides are preparing their arguments, and the judge will ultimately decide how the evidence should be interpreted. Possible outcomes range widely. The court could accept an explanation and move forward with minimal consequences. It could impose sanctions related to the filing, or it could decide further investigation is necessary. For now, the most important fact is simple. The documents exist. The contradictions have been raised, and the courtroom will be where those questions are answered. Because once testimony is given under oath in a federal proceeding, the record becomes permanent, and whatever explanation emerges from that hearing may shape the next chapter of this case. Until then, the legal world is watching closely, waiting to see how a $127 million transaction, a sworn affidavit, and a stack of internal records will ultimately collide inside a federal courtroom.